I'm Dave Martin, ICFRC President and host for today's program. ICFRC hosts community programs to address topics of international interest. We thank our members, volunteers, and interns for making these forums possible since the year that our speaker, Jonathan Carlson, joined the University of Iowa College of Law as a faculty member, 1983. I want to acknowledge our university and community supporters, the University of Iowa's international programs, the University of Iowa's Honors Program, the University of Iowa Center for Public Policy, and the Stanley UI Foundation Support Organization. And we thank today's special sponsors, Alan Swanson, Blank & McCune Realtors, Dave Wu, and Mason K. Braverman. We also thank City Channel 4 for professionally recording our programs on cablecast, on City Channel 4 or 118-2, and we thank UI Libraries Digital Archives. Over 220 ICFRC podcasts can now be found on iTunes. It's my pleasure to introduce John Carlson. He graduated with honors from the University of Chicago School of Law, where he served as Topics and Comments Editor of the University of Chicago Law Review. He then began his legal career by clerking for Alvin B. Rubin of the Circuit Court of Appeals for the Fifth Circuit. He entered private practice with the law firm Patton, Boggs Blow in Washington, D.C., before joining the faculty of the University of Iowa College of Law in 1983. His research focuses on international law and the environment, and he has authored several law review articles. Today, he will examine the Trump administration's actions and rhetoric with respect to the international rule of law and consider whether the Trump administration's behavior reflects a sharp change from the past or merely a more honest and straightforward presentation of a long-standing American First approach. Please join me in welcoming John Carlson.
Thank you so much, Dave. It's really a pleasure to be here. See so many old friends and such a good turnout. This is one of the great Iowa City institutions. It's been here my whole life here, and I'm very honored to be here. For more than 70 years, I've got to remember to hit my slides. I'm sorry, I'm not always good at that. For more than 70 years, the United States has been a leader in the effort to build and sustain a rule-based multilateral international order. And as envisioned by the men and women who established this system, the post-World War II order would be based on rules about war and peace, rules about refugees, rules about occupied lands, rules about human rights. The international order also included the establishment of an international court of justice to resolve disputes by application of the rule of law. And the system was intended to rely heavily on multilateral institutions. The United Nations, of course, was at the center of it, but we also had, in addition, the IMF and the World Bank, which were formed to ensure that international lending practices and international currency policies promoted international values. We had the General Agreement on Tariffs and Trade to deal with trade issues. It was intended to include an international organization on trade, but that didn't happen until 1994. So basically, we had an order that was intended to be based on rules, on law, and on multilateral cooperation. The framers of this system, I guess I have a slide, sorry. The framers of this system were not delusional, nor were they naive. They understood that power matters. They understood that sovereignty is the fundamental organizing principle of the international system. They accepted that. So they created a one nation, one vote General Assembly. But if you read the UN Charter, you'll realize the General Assembly has no power to do anything except make recommendations. The real power went to the Security Council. And in the Security Council, they placed the 5 most powerful nations among the victors after World War II, gave them permanent seats, and gave them a veto. The International Court of Justice has the power to decide disputes based on international law, but no nation has to agree to its jurisdiction. Its jurisdiction is based on consent. So they created a multilateral rule-based international order, but they did not create a world government. Nonetheless, the thrust of, I'm not sure if I'm, well, we'll get to that. The thrust of the post-World War II system was to promote fundamental values, to strengthen the rule of law, and to build global solidarity. And I like to think of it this way, that their basic idea was, we're all in this together. As a global community, and that as a group we're determined, as the UN Charter puts it, to save succeeding generations from the scourge of war, to reaffirm faith in fundamental human rights, to establish conditions under which justice and respect for international law can be maintained, and to promote social progress and better standards of life in every country. So our country is not perfect, right? And our actions have frequently diverged from those ideals. But on many occasions, we've been a major force, I would submit, even the leading voice in the post-war effort to build global solidarity. We have been generous with our money. We have been vocal in our support for fundamental human rights. We have been strong in our resistance to incursions against the basic norms of the system. And the question, my question for today is, has that changed? The rhetoric of our leader has most certainly changed. In place of the general theme that we used to hear from presidents of support for international norms and institutions, Trump has indulged in a rhetoric of America first that is characterized by expressions of resentment and anger against other nations and against global institutions. And he's backed up that rhetoric with a whole long list of actions that, taken as a whole, seem to signal a fundamental shift in our nation's relationship with the rest of the world. And the list began to form actually just 3 days after he took office, and has continued to grow throughout his 2.5 years. So I want to hit some of the highlights, or lowlights if you prefer. On January 23rd, 3 days after he was inaugurated, he announced that we were done with the Trans-Pacific Partnership, in which we had played a leading role, in the negotiation of which we had played a leading role. On June 1st, he announced that we were done with the Paris Agreement on climate change, that we would immediately cease implementation and we would withdraw as soon as the treaty allowed, which hasn't happened yet. On October 23rd or October 12th, we announced that we were withdrawing from the UNESCO, the UN Economic, Social, and Cultural Organization. On December 3rd, this is all 2017, on the eve of an international conference to discuss migration issues, we announced that we were withdrawing from the negotiations, because even talking about migration would be an affront to our sovereignty. On January 6th, Trump recognized Jerusalem as Israel's capital, a move that was not greeted happily in many international circles, but we'll get back to that. And on December 24th, after the UN General Assembly passed a resolution criticizing the U.S. action, he announced that we were going to, in cut our contribution to the UN by $285 million. That's 2017. 2018, March 1st, Trump announces a 25% tariff on steel and a 10% tariff on aluminum, which he says is for national security reasons, which is transparently for economic protectionist reasons and a violation of the GATT agreement, and our trading partners quickly retaliated. Trump says, don't worry, trade wars are easy to win. May 8th, we denounced the Iranian nuclear accord. June 19th, we withdraw from the UN Human Rights Council and give up our seat. July 11th, Trump goes to NATO and lambastes our allies in NATO, Germany and others, saying, A, they don't spend enough in their own defense, and B, Germany is controlled by Russia anyway because they buy natural gas from them. On August 28th, 2018, we end our support for the UN Relief and Works Agency, the UN agency that provides humanitarian support to Palestinian refugees, and to which we have been the major contributor for many, many years. On September 11th, National Security Advisor John Bolton, who has just gotten wind, or recently gotten wind, that the ICC may be examining war crimes in Afghanistan by the Taliban, the Afghan government, and maybe even the U.S., Bolton declares the ICC to be an illegitimate court, and he says that if they investigate anything in Afghanistan, we will prosecute the judges criminally in the U.S., we will ban their travel to the U.S., and we will impose financial sanctions on them personally. Okay. 2019 begins sort of where 2018 left off. On February 2nd, 2019, we announced that we are withdrawing from the Intermediate Range Nuclear Forces Agreement. And on March 21st, 2019, just 2 weeks ago, we announced that we'll recognize Israeli sovereignty over the Golan Heights, an act that is in direct violation of 2 Security Council resolutions, and most people would say the fundamental legal principle that territory should never be gained by force. In virtually every case, the language accompanying these moves is a familiar Trump litany of resentment, anger, and jingoism. From Trump's perspective, I suppose you would say that he has declared our independence from a multilateral international order in which we lose, 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 and move toward a power-based world order in which we are going to win, win, win through the negotiation of bilateral or plurilateral agreements and arrangements that serve our interests. So it's not my desire to discuss the merits of any of those actions I outlined for you, independently or together. I mean, each of them we could have an hour-long debate, at least, on whether they were wise policy or good moves. What I want to talk about are 2 questions. Are we seeing a fundamental shift in the American position toward a rules-based multilateral order, a shift away from that commitment? And if we are seeing a fundamental shift, should we worry about it? Is this just Trump? It'll go away when Trump goes away, or is it something else entirely? So that's what I want to talk about. Many leading international lawyers in the U.S., I have to tell you, many leading international lawyers in the U.S. say, there's nothing to worry about. Consider what Sean Murphy, he's a professor at the George Washington University Law School. That wouldn't be enough for me to quote him, but he is also the current president of the American Society of International Law. So he is a leading voice. Consider what he has to say. Writing in the Society's recent newsletter, he addresses the question whether we're seeing a major realignment in the way the U.S. approaches international law and international organizations, or something else. He says, no, we are not seeing a major realignment. For him, the key observation is that none of this is new. None of this is new. And indeed, he's right that a lot of it is not new. The withdrawal from the Trans-Pacific Partnership. Trade agreements are always contentious and always hard. And we would have withdrawn even if Mrs. Clinton had become president. She made that clear. Criticism of the International Criminal Court. There's nothing new about that. The Clinton administration signed the treaty creating the International Criminal Court, and the Bush administration said we're never going to ratify this treaty. And there were a lot of people who agreed with that. Withdrawal from UNESCO and withdrawal from the Human Rights Council, been there, done that. We've quit both those organizations before. Nothing new there. Withdrawal from the Intermediate Nuclear Forces Agreement. Well, some of you will remember, we also quit the Anti-Ballistic Missile Agreement. So Murphy says the U.S. relationship to international law and international institutions has always been a complicated picture, oscillating between engagement and withdrawal, engagement and withdrawal. And so he says, don't worry. Another view is expressed by Harold Koh. Harold Koh was is probably the most knowledgeable and well-connected international lawyer in America. He's a professor at Yale Law School, but he was also under Obama the legal advisor to the U.S. State Department. So he is well known, and there's nobody who's more connected and more looked up to than him. And Koh's argument is this. He says international law is embedded in our laws and in our ways of doing things to such an extent that Trump is unlikely to be able to do any permanent damage to it, and any permanent damage to our support for multilateralism. And I want to read you a quotation, so I hope you'll forgive me, from his recent book on this subject. Here's what he has to say. A pattern has emerged where Trump announces that he will disrupt a previously settled relationship. The media reacts, the allies and opponents push back, and policy resettles roughly where it was before. He says foreign policy toward lower profile nations and toward issues, lower profile issues, continue to be governed largely by lower political appointees, career bureaucrats, and standard operating procedures. So key national security and defense policies continue to be made according to long-standing legal and policy principles, often embedded in established legal and policy frameworks and in congressional statutes, executive orders, president policy guidance, and institutional custom. So I call this the deep state will save us thesis. I suspect that's what President Trump would call it as well. I hope that Murphy and Koh are right. I hope that all we are seeing is a cyclical blip that will not significantly disrupt our deeply rooted national commitment to multilateralism and the rule of law. But I have to say that I am not convinced they're right. And in the remainder of this talk, I'll give you 3 reasons why I'm not sure that they're right. And then, since it's pretty gloomy analysis, I'll end with 2 reasons why I'm nonetheless an optimist. So my 3 reasons for concern are these. The Trump administration is rejecting the international rule of law and celebrating sovereign interests over community values in some ways that we haven't ever seen before. It's not all been there, done that. Second, the rejection of the international rule of law is not unique to Donald Trump. It's a turn that's been taken in a number of quarters in America, and especially, I hate to tell you, by America's legal community. And we will come to that. And then the third reason I am a little gloomier is that I think this rejection of the rule of law is actually rooted in the terms in which some of our intellectual discourse has taken place for the last 20 years. Or 30 or 40 years, I should say, maybe even 50. And I'll talk about that. So let me begin with my first point. What we're seeing is different in kind than anything we've seen before. And I have two examples, and perhaps I would have to give you a little more detail about them than you will care to hear. The first example relates to the Trump administration's policy toward the World Trade Organization. Everybody knows that we're in a trade war with China, Europe, and others. What is far less known is Trump's war against the rule of law inside the WTO. In 1994, when the WTO was created, we, in the United States, insisted that it include a dispute settlement mechanism that would allow for the application of the rule of law through decisions that would be binding on the member nations. We were trying to get away from a system where decisions were made, but nobody felt bound by them, and they were compromises, not legal decisions. So we insisted on a system that had the rule of law. And the system was structured so that if you have a dispute with another country, first you negotiate and consult. Then if you can't resolve it, you go in front of a panel of trade experts, diplomats, not necessarily lawyers, who will examine the facts of the dispute and decide how they think it should come out under the WTO rules. And then if you want, you can appeal to a group of lawyers who were appointed to serve independently of their governments, the so-called appellate body, and they would decide the case on the basis of the rule of law. And they were explicitly authorized to interpret the agreements according to international legal rules about interpretation. So we have this system in which the U.S. is the chief proponent, aimed at resolving disputes under a legal process with binding interpretation of agreements by judges. We don't call them that, but judges who are legally trained. And the system has worked very well for over 20 years. There have been occasional exceptions, but most appellate body decisions, even controversial decisions, have been complied with by the losing governments. And more to the point, the appellate body has been seen as rendering fair, impartial decisions that are firmly grounded in the law of the agreements. For the U.S., it's been a particularly good system. We've lost some cases, but we've won considerably more than we've lost. We win 86% of the cases that we bring, and we lose a far lower number of the cases brought against us. We have more success than any other country. Perhaps because we're more law-abiding than many other countries. The Trump administration has decided to destroy this system. And it can do this because judges to the appellate body have pretty short terms of service, and they have to either be reappointed or a new judge has to be appointed. And under WTO rules, you appoint judges by consensus. Everybody has to agree that this person is suitable to serve on the appellate body. And under the Trump administration, we won't agree to anybody. We reject all nominees. Doesn't matter who they are, doesn't matter what they believe, we refuse to accept them. So the appellate body is supposed to have 7 members. It sits in panels of 3. It now has 3 members. And it can't keep up with its workload. And as of next November, one of those members' term ends. It will then have 2 members, and it won't be able to do anything. And the Trump administration is fine with this. It is doing it deliberately. It's completely under the radar. Right? It's just too much in the weeds for most of us when we read the New York Times to worry about that, or whatever paper we read. But that's what they're doing. So why is he doing it? Well, I'm back to the wrong one, sorry. Why is he doing it? Well, he would say he's trying to encourage the WTO to reform itself. Most people think it's because the appellate body has not been deferential to our interpretations of the WTO agreements. They've said, no, that's not what it means. And the Trump administration has made it plain that they think that a group of international judges should not have the right to tell us what the agreements we entered mean. We should have the power to do that on our own. That's their explanation. It seems to me, really, though, that the fundamental reason is this, that the Trump administration believes that it can better pursue U.S. interests through power-based negotiated resolutions of trade disputes than through law-based resolutions of trade disputes. That's ultimately what it's about. And they have figured out an avenue to prevent any law-based resolutions of trade disputes that might embarrass them, and they're carrying it out. We haven't seen anything like that in at least 30 years, perhaps longer. And that's one way I think the Trump administration is different. It's apparent contempt for rule-based multilateralism in the trade arena, which we've been the champion of for most of the post-war period. The second arena of concern has to do with the Israeli-Palestinian conflict. I imagine that many of you in this room, maybe most of you, are supportive of some of the things that Trump has done. And I respect that. In particular, his recognition of Jerusalem as Israel's capital has pleased many Americans, although it's opposed by some who think that that issue was one of the negotiating chips that would help reach a broader resolution. But that recognition of Jerusalem, that's a small thing. You could say, been there, done that. Congress has passed a law requiring that, which Obama refused to follow. But the other things he's done are a little bit different. Although it didn't get much by way of headlines, Trump withdrew funding from the UN Reliefs and Work Agency, which provides humanitarian aid to the Palestinian refugees in Gaza, the West Bank, and elsewhere. And that has consequences, because the way it was interpreted around the world, and I think the way the administration intended it to be interpreted, was that we no longer recognize the Palestinians as refugees. The refugees are long dead. These are their sons, daughters, grandchildren, and we no longer see them as refugees and are no longer going to support a refugee relief program. And what are the consequences of no longer seeing them as refugees? Another bargaining chip is taken off the table in terms of the reaching a resolution of this. And the bargaining chip that's gone is the so-called right to return. Nobody, I think, ever really thought that the Palestinians would be given a right to return. But the claim of a right to return was something that people thought they could trade off for land on the West Bank and elsewhere. But that's gone, at least from the U.S. perspective. And whatever your view on those two things, 2 weeks ago, there was a move of a completely different nature. And that was where the Trump administration claimed that Israel had sovereignty over the Golan Heights, a region of Syrian territory that Israel captured in the 1967 war. In making this claim, Trump violated or ignored the terms of two long-standing Security Council resolutions on precisely this issue. Said precisely that, occupied or not, Israel does not have sovereign authority, and that its purported annexation of the Heights was a violation of international law. Maybe it would have kept it, but the Security Council was keeping that as a bargaining issue. Trump's action was also contrary, I would say, I would assert, to a fundamental rule of the post-World War II international order that territory cannot legitimately be acquired by the use of force. And the risk here is really quite grave. Prime Minister Netanyahu, immediately after Trump's action, stated that this just goes to prove there is no absolute rule against the acquisition of territory by force. Netanyahu said, if you're acting in self-defense, Netanyahu said, you can acquire territory by force. It's lawful to acquire territory by force. That's how Prime Minister Netanyahu interpreted that. So think about the implications. He is saying, in effect, or he's implying, in effect, that our next step is to annex the entire West Bank because our acquisition of that territory was lawful. And that would undermine the entire basis upon which efforts to find a solution to this conflict have been based. You could fairly think, and I'm not getting into the foreign policy aspect of this, but I have to say, you could fairly think, good, the efforts have never worked, the basis for them should be undermined. But we ought to at least see that that's what we're doing. But there's another problem, even if you think that's a good move by Trump. If the Israeli interpretation of the U.S. position prevails, if this is in fact the U.S. position, that you can lawfully acquire territory by the use of force if you were acting in self-defense, it really opens a can of worms. Although Israel does and can claim that it acted in self-defense in 1967, we should remember it struck first. It attacked first, bombing the Egyptian airfields and invading Egyptian territory. It was provoked, but it struck first. And if what we're saying is that if you're acting in self-defense, even if you are the first striker, you can acquire territory by that fact, then we're creating grave risk in every border conflict in the world. And we have border conflicts between Russia and the Ukraine, between Russia and Georgia, between other countries in that region of the world, between Pakistan and India, between China and India. And we're saying that either country, whichever one strikes first and says it's acting in self-defense, can acquire territory lawfully. It strikes me that taking such a position strikes at the heart of the UN Charter provision that against the use of force, that prohibits the use of force against the territorial integrity of other states. I'm running out of time, I'm sorry, so I have to run through this a little bit more quickly than I intended. So I see some fundamental differences. The second reason I'm concerned, I said, is that I think that the turn against international law is a long developing and deeply rooted, especially in the U.S. legal community. There's a lot of evidence about this, but I'll just give you a few examples. Let's begin with the Supreme Court. Over the past 30 years, and reflecting a definitely nationalistic turn, the Supreme Court's decisions have consistently weakened the role of international law in our legal system, either reversing or whittling down prior precedents, either reversing or whittling down prior precedents about the role of international law. The Alien Tort Statute was a statute that was used in the 70s and 80s to allow aliens who were tortured, who were the victims of terrorism, who were the victims of human rights violations, to bring suit in the U.S. against their tormentors if they could find their tormentors in the U.S. The Supreme Court in 1992 started saying no more. The first thing it said was you can only enforce customary international law if it's as clear as the law in the 18th century. Well, that's a pretty open-ended thing that allows any judge hostile to international law to say, oh, that's too vague and mushy, we're not going to enforce that. That didn't entirely work because there were plenty of judges who said, well, human rights law is plenty clear. We're going to enforce it. So in the 2000s, the Supreme Court said, wait. This statute doesn't say that it applies to violations that take place outside the U.S. So we're going to say the only international law violations that you can sue about are violations that occur in the United States or that are some other way closely connected to the U.S. And then, even that wasn't enough. When victims of terrorism by Arab or Palestinian groups in the Middle East sued a bank for financing those terrorist activities, an Arab bank that did its financing by passing money through the U.S. The Supreme Court said, oh, and by the way, you also can't sue corporations because international law doesn't reach corporations. So much for customary international law enforcement in the United States. They've done similar thing with treaties. The Constitution says that treaties are the supreme law of the land. The Supreme Court has long said, for 200 years it said, well, there's an exception to that. If it's clear from the face of the treaty that the parties don't intend it to be enforced in court, but intend legislation or something else to be passed, then it's not the supreme law of the land. It's not self-executing. In 2010, the Supreme Court sort of flipped this on its head. It said, in effect, no treaty is self-executing, no treaty is the law of the land, unless it's clear that Congress and the President, when they ratified the treaty, intended it to be enforced by the courts. So now it becomes very difficult ever to enforce a treaty, despite what the Constitution says. And they went further, and they said, oh, by the way, we used to say that the President, pursuant to his duty to faithfully execute the laws, could enforce treaties. But since we've just said that treaties aren't the law, he can't enforce them either, except in the very, very narrow class of cases that we've covered here. And, the court in doing this is not, I have to say, out by itself. It's reflecting a strain of conservative thought that dominates the legal scholarship on this issue. Dominates it. And they're not alone. Beginning in 2010s, states started passing all sorts of laws about how prohibiting their courts from ever applying international law. And much less never applying international law, you can never apply foreign law, which is a weird proposition. Suppose I get married in France, and the question is my marriage valid? I don't get to apply French law in an American court to decide whether my marriage is valid. It's an absurdity. But many, many states have passed such laws, and it reflects a fundamental turn against international law. So Trump, I would say, is a mirror. And that's why I'm a little more worried about this than some people are. He's not out there on his own. I'm going to skip some of these. The intellectual roots of all this, I think it has deep intellectual roots in what I was taught in my college career, what many students were taught. And I'm going to caricature here some intellectual theories. I know it's a caricature, but I will say this. What do you think students take away from school? Most of them, when they hear complicated intellectual theories, accept caricatures of those theories. One, I will say, is the rational man theory. The notion that we learn that politics and law are all about people pursuing their own self-interest. And the laws we end up with are the laws that interest groups get in their own interests. There's no such thing as the public interest. Whatever veneer of public interest a legislature puts on the law, it's ultimately in the service of some private interest or another. And politicians themselves are most of the time voting in their own interest, either voting the way they need to vote to get money to run for re-election, or voting the way they need to vote to get votes. They aren't thinking of the public interest. That's from the right. From the left, we've got social construction of reality. And here's what I think students hear when you talk about social construction of reality. Values and principles? Don't give me stinking values and principles. There's no such thing as a fundamental value or principle. Reality and law and values are socially constructed, and in particular, they are made by the powerful for the purpose of oppressing the weak. And the key to solving problems is not to find the public good or find the public interest. The key is for the weak to rise up and strike down this powerful, take the power away. Oh, and by the way, you know, we on the left agree with those on the right. Politicians just vote in their own interests. They aren't serving our interests as a group. I appreciate I'm characterizing this. But I think students and the general public, they hear the caricature. They don't hear the nuances. If this is how we feel about our own country and our legal political system, that it's simply a veneer for naked pursuit of self-interest and power, and I think that's what a lot of people think, then Trump's turn away from rules, his turn away from a search for cooperation in the common interest, his turn toward a power-based pursuit of American interests is a reflection of our national mood and is not a passing problem. If you think I overstated, I sure hope you're right. But I did this little thought experiment for myself, and I'll give it to you and see what answer you come up with. Can you imagine either Mitch McConnell or Bernie Sanders uttering Kennedy's line, "Ask not what your country can do for you, ask what you can do for your country"? I hate to say it, I can't imagine those words crossing their lips as an original thought. They might say them for rhetorical flourish, but not as an original thought. And I do have to say that what I have said about the turn away from the rule of law is true on the left as well as the right. I think the very first question on your little quiz asks you where did anti-globalism start or something, and the answer is at the protest against the WTO. The left has always hated the international rule of law, or a certain fringe of the left, as it's applied to the WTO. And Bernie Sanders has, in particular, condemned WTO decision-making and might applaud Trump on what he's doing to the appellate body in the WTO. So, I'm out of time, but I said I'd do hope, so I'll give you the hope really quickly. Two things that make me hopeful. One is young people. Every day I see young people, who are really public focused more than any time that I've been here. And I think the young people in Congress are of this ilk. You know, some people call them socialists. I call them optimists. You know, whether or not I agree with what they're thinking, I think they are public interest focused and are very optimistic about it. So that's the first reason. The second reason I'm more hopeful is that it's knowledge. There are important developments in social psychology going on that can act as a counterpoint to those views about everybody serving their own interests. It's all about power and oppression that we've heard. And there are a couple of things Do I have it on here? First, the social psychologists are discovering that altruism is not epiphenomenal. It's not something people make up to explain why they're doing something that they're doing in their own interest. It's really a human motivation, and a fundamental human motivation. And there's very good evidence of this through various kinds of experiments. And that's a good thing. That suggests that we can search for a public interest. The second thing is the coalitional psychology. So what's coalitional psychology? The bad part of this is it's true. We tend to be tribalistic and we tend to be nationalistic. We tend to favor our group. The good thing is you don't have to define the group in terms of your fellow citizens or in terms of your race or in terms of your political party. You can define the group, and those of us who go to church know this from church, or we used to. You can define the group in terms of your shared commitment to an ideal. And you can build your coalitional psychology around that commitment. And both these things give me some hope. And so I end with what Lincoln said to his people in the city of Springfield as he left to go off to become president, knowing he was going off to face a pretty horrible situation. He said, "Let us confidently hope that all will be well."
Okay, John, there's a couple of questions here. Number one, would you agree that certainly the reputation, respect, and confidence in the United States has greatly diminished under Trump? And secondly, what would it take to turn the Supreme Court more responsive to international law? Or is there a possibility of that? I guess it's...
Yes, I'd agree with the first one. What was it? that the world's confidence in us as a leader of law, multilateralism, whatever you want, has been diminished significantly. I think they are all, like many of us who are Democrats, I hate to get too political, are just hoping for the end. Dave asked me today, are you going to stick to your letting your hair grow until Trump is no longer president? I said, I don't know. I don't know if I can make it. But yeah, so I agree that's true. What would it take to turn the Supreme Court? I don't know the views of the people who Trump has recently appointed. I suspect they are the same views as the conservative majority that's existed since '92 with respect to international law, which is, and I should say it's more nuanced than I portrayed it. It has two dimensions to it. One dimension is that we should not accept that externally made rules are a restraint on our domestic law unless there's extremely good reason to do so. That explains not treating treaties as trumping local law unless the Congress says so. And the second dimension is it's up to the politicians to make these kinds of decisions about when international law should apply in our system or not. Neither of those are ridiculous propositions. They're just not entirely consistent with our legal tradition, and they're troubling. But I suspect the new justices, any justice coming out with Federalist Society approval, will share this attitude. And they've learned this attitude from their professors at Harvard, not at Yale, but at Harvard, and Harvard graduates way more lawyers than Yale. So what will it take to turn? A completely new generation. of lawyers. We're talking about hoping that the lawyers in their 20s and 30s now, who are now in their 20s and 30s, have a more favorable view of international law. I don't know that they do. Most young law students, most of them ignore it until they're forced to deal with it, and then their views are shaped by their political ideology and other things.
Without addressing issues of collusion or conspiracy, isn't what Trump is doing in accord with Putin's desires regarding attacks on the columns of democracy and Western alliances?
I suppose that's I would say that's if I were debating with whoever asked that question, I'd say that's a fair statement. I don't. As long as you let me put aside collusion and not ask the question, are the two of them plotting to do this, which I very much doubt, but.
Fair enough. This is a little more technical question. I thought the Alien Tort Statute applied only to actions and violations that had occurred outside the U.S., and then if victim is inside the U.S., they can sue their attacker. Please clarify. That right there.
It applies only an alien, a non-U.S. citizen, can bring a claim. So when this statute was rediscovered, because it was passed by the very first Congress in 1789, but it lay dormant for many, many years. When it was rediscovered and began to be used, it can only be used by a foreign citizen suing someone who has caused damage to them in connection with an international law violation. So it was originally used against actions that had been taken outside the United States. Because, frankly, we're much better about respecting people's human rights, especially the fundamental ones. Not perfect, but better. So the first big action was a family of a man who had been tortured to death in Paraguay, who found the general who had ordered the torture in New York and sued him. So the early actions did indeed pertain to conduct that had occurred outside the United States. And that's what you would expect, since it's a suit by aliens. It's only for non-citizens. But what the Supreme Court has said is that no, it can only apply, we're not going to apply it in that situation anymore. It doesn't apply extraterritorially. The conduct must have happened in the U.S. Or there has to be some other really close connection to the U.S. Well, you can see that the conduct must happen in the U.S. That virtually eliminates all these suits against human rights violations, torture, environmental law violations elsewhere in the world. And then when they said, and you can't sue corporations, that sort of eliminates any connection to the U.S. other than where the conduct occurred, because people thought, well, if we find a U.S. corporation or somebody doing business in the U.S. closely tied to this violation, we can at least get them. And the Supreme Court has said no. Now, why do they say that? They say, well, we've decided, nobody knows why the first Congress passed this statute, but we think they most likely passed it because American citizens were attacking ambassadors from countries they didn't like. And it was passed to give those ambassadors a remedy against the Americans who were attacking them. And since they were probably thinking of that situation and inside the U.S. conduct, we're not going to allow the statute to extend beyond that. anymore, because there were plenty of cases where it did.
Okay, one more that's related a little bit to one of the previous questions. Is Crimea next on Trump's list after the Golan Heights?
I've often wondered why he doesn't just go out and do it. So my thought is, yeah, probably, but I can't see any motivation for him to recognize Russia's sovereignty over Crimea. I can't see any domestic political motivation for him to do that. I see plenty of domestic political motivations for him to recognize Israeli sovereignty over the Golan Heights. I mean, those of you who have debated with yourselves or your friends or your family about the Israeli-Palestinian situation have probably debated this very issue, and there's a strong view among some people in the U.S. that Israel should be sovereign over the Golan Heights. It needs it for its security. The U.S. has declined, and so by recognizing it, I think he's appealing to a certain group of people that he hopes may become his supporters. And I don't see any similar motivation to recognize Russia's control over Crimea, but I don't see why he wouldn't either.
Okay, we now conclude our program, and let's give a big thanks to John for his presentation. I also want to thank our sponsors, the University of Iowa's International Programs, the University of Iowa's Honors Program, the University of Iowa Public Policy Center, and the Stanley UI Foundation Support Organization for their generous support. We thank today's special sponsors, Alan Swanson, Blank & McCune Realtors, Dave Wu, Mason K. Braverman. And we thank City Channel 4 for making our programs available to viewing audiences. And John, as a small token of our appreciation, we'd like to present you with the coveted Iowa City Foreign Relations Council mug.
New colors.
We are adjourned.